Very good, Mike. Let's shift bases a little bit and let's talk specifically about some of the federal legislation that has been discussed over the past few months or even a few years. I know you do quite a bit of work in the mass tort context, and one that touches on that is this Litigation Funding Transparency Act, which has been batted around in a couple forms and fashions. Why don't you break that down for us?
Yes, sure, happy to. So there's been a number of initiatives that have come up, particularly over the last 4 or 5 years, to try to create some type of regulatory regime at the federal level. Of course,
Hmm.
which is challenging because our court system is basically a state-based court system for the most part. So the
Hmm.
question becomes is what is the role of the federal government in legislating this versus state governments versus the courts? And I think obviously the courts sort of remain in the best position, I think, to help regulate this industry in some way. But there has been efforts over the past years to try to create a federal regime, and I continue to sort of think that they're trying to address it's sort of a solution in search of a problem still, in my view, still. I am a supporter of certain levels of regulation in certain contexts. I think that's going to be important for the safety of our industry, but also the growth of our industry going forward and the
Hmm.
confidence in our industry going forward. But I look at things like the Litigation Funding Transparency Act, and I see the Protecting Our Courts from Foreign Manipulation Act of 2023. There's always exceptions to rules in every type of situation, but I'm not seeing the type of broad-based risks that this proposed legislation is endeavoring to address. Uh,
Hmm.
Not saying that it's not there at all, but I'm saying I think it's the outliers that we're seeing, and I think it's never a good idea to legislate to the outliers because there's unintended consequences of doing this. Because much as we've seen a lot of the regulation, there's a tendency sometimes to go to extremes, and I always wonder in the end of the day, while we might be trying to solve and protect against certain type of risk, whether it be at the federal or state level, what in the end will be the impact on the individuals, the small companies, even the larger companies, who may suddenly lose access to financing that might in fact allow them to pursue their meritorious claims. And
Right.
I think there's also an implication behind some of these legislative efforts, that there's something sort of untoward about the industry in some way, that's got some surreptitious, something risky is going on here. And we're in this industry every day, and we probably do 40 transactions, 50 transactions every year. We've done over 300 transactions, been involved with this, and it's hard for me to recognize in the work that we do what a lot of the legislation looks like they're trying to address. So
Right.
it's sort of empirically, I just don't see it yet, and I really get concerned that for a lot of our clients where we've seen some really remarkable outcomes, they would have not have had those outcomes, which are of course based all on meritorious claims, without the funding. And there's some risk that may be compromised or taken away. So, are the federal, is the federal government in a position to legislate this? Probably not. Maybe the states are better positioned to do it, but I do think that ultimately in the end it should stay back in the courts.
Yeah, I mean, look, the Litigation Funding Transparency Act is weird, frankly, because it really targets mass tort and class action to an extent. And in the situations where a court has said, I have a concern about this, they've dealt with it. I mean, you look at like opioid in Ohio. Okay, there was a standing rule that there'd be an in-camera review of a litigation funding arrangement. The court essentially raised it on its own volition, and we dealt with it, right? But the idea that the federal government stepping in on something like that is just weird, frankly.
I
An
mean,
even weirder one. Go ahead.
well, I was going to say, and I think, there, and maybe you're getting ready to turn to this now, but I think the idea that, there is maybe a role for the federal government in terms of, foreign engagement in our court system. But again, I think, we obviously represent a large number of investors who are not U.S. investors. Actually, my very first client, the one I referred to early on, that fund was basically funding brought in from non-U.S.
Right.
investors coming in. But they're a highly reputable group of funders and investors coming behind. So do we throw out the baby with the bathwater sometimes in our approaches? And also, don't we have other legislation in place already, which helps to address some of the risks that are being identified? So I didn't mean to jump ahead of you there.
No, sure. I mean, look, you went exactly where I was going to go with this, which is something that's caught my eyes. This Protect Our Courts from Foreign Manipulation Act of
Mhm.
2023. And this one's really interesting because, like, here you do have a federal issue, which is
Mhm.
ostensibly, you know, dirty foreign money coming in and trying to manipulate the legal system, um, um, through the use of litigation finance. And this is like conspiracy theory 101. And it's not to say it doesn't happen, right? You have, I'm sure you saw this as well, the article in Bloomberg a couple of weeks ago. It's a great article, really interesting about, Russian oligarchs coming in and somehow intermeddling in cases. I actually I'm working on a case now. It's the enforcement of a very, very large Chinese judgment in the U.S. courts, and it's very similar issues, right? One hand, does the Chinese government or do Chinese oligarchs have in this stuff? And ostensibly, this legislation is meant to address stuff like that. But I come back to what you said, which is I question how big of an issue is this? Are there other ways of dealing with it, whether it's, you know, anti-money laundering, laws or, frankly, using this information to impeach the party seeking to actually do whatever they're trying to do, whether it's enforce a judgment or get some liability in the U.S. But I don't know if this is, to me at least, an important use of broad sweeping federal legislation that could have unintended consequences on foreign investment vehicles.
Sure. I mean, one of the areas we see this coming up a lot is in the intellectual property space,
Oh
right?
yeah.
There's a concern that an adverse, foreign interest will come in through the funding and somehow get access to technology or access
Yeah.
to important information. I think the risk is sort of misplaced. I mean, I'm much more concerned about parties who've had adverse interest, gaining access to parties who are actually doing the infringing,
Hmm.
because that's when they actually get to see the technology. They get to
Right.
actually use the technology. And I think, again, are we really just talking about some outlier cases? How broad is this risk of some foreign
Hmm.
manipulation of our court system? Again, we have we have a large number of clients that are international funders, and they have very stringent disclosure regimes in their home countries. We have existing disclosure regimes here through the new Corporate Transparency Act. We've got the SEC, sort of private equity, private funds kind of rules for more
Right.
disclosure about these kind of interests. And then, of course, you have the whole array of lobbying laws as well that come in. So, are we trying to legislate something that is otherwise already better addressed through existing laws?
Right. Right. So and my next bit, I guess I have a question for you. I think soon. I recently wrote a chapter of a textbook that's talking about legislation, litigation, finance. So I had reason to read some of these rules, and I'm reading through, half a year ago. Um, I think something that caught everybody's eyes was this SEC rulemaking concerning private equity funds or private equities disclosure of what exactly they're investing in. And
Mhm.
the whole litigation finance market was looking at this and saying, oh, it calls out litigation finance
Right.
directly. But then I read the rule and I'm like, oh my word, this is like I think it's actually a footnote where they use the word litigation finance or litigation funding, whatever it is. I mean, you're a funds guy fundamentally, sure, you focus a lot on litigation finance, but you're a funds guy.
Right.
I mean, is this something that specifically targets litigation funding, or is this okay, we're going to make everybody disclose a lot of different asset classes, and among that might incidentally happen to be litigation funding?
mean, I think it's a recognition that there is a lot of capital that's
Okay.
being raised and is flowing into this asset class, which we didn't have necessarily some time ago. And I think the SEC, as it probably should be doing, is looking to protect the investors behind the investors,
Right.
and are there proper allocations? Are they properly factoring in risk? And I do think that given some of the very, very large amounts of capital flowing into this industry, that the SEC is right to take a look at that, and
Sure.
as one of many factors to consider in
Mhm.
terms of properly balancing, the interest of investors, in a lot of these multi-strategy and other sort of private equity groups. So, for me, it didn't strike me as anything that was particularly unusual. I know it was specifically called out, but I think that's kind of just recognized by the increasing amount and volume of
Sure.
cases and money flowing into the industry.
Got it. Look, neither your practice nor mine touches terribly upon, consumer litigation finance, which has been, plaintiff advances to personal injury plaintiffs predominantly, and that has been the subject of some legislation at the state level over the years. You have, it's actually really interesting. You have some states like West Virginia, Montana that have effectively, rendered the business inoperable because they have some fairly stringent stuff. Compare that to states like New York that, as consistently operated under a handshake with the attorney general. Most of these do not talk to commercial litigation funding, which is what, you and I are dealing with most often. There is an exception, which is basically inoperable right now, but it was the Florida's Litigation Investment Safeguard and Transparency Act
Right.
that it was batted around throughout 2024. From your perspective, were you paying attention to this, and what kind of jumped off the page to you as a potential thing that you should be navigating as a transactional attorney?
Sure. I mean, it was something that was very much on our radar,
Hmm.
in part because we have a number of clients that are based in Florida, but also a lot of financing activity occurs sort of into and out of that market. So we're being sort of really attentive to this, and at least for now, it seems to be process seems to have been sort of slowed down for now. But a couple really interesting things about it. You already touched on some of them. One is it really does focus around the commercial funding space and not the consumer space, which,
Hmm.
again, like much of the existing state legislation, is really in protecting sort of individual consumers. So this seemed to be more an effort to try to regulate the industry rather than protecting individual consumers per se. So it's interesting that the Florida bill, did focus on commercial funding. There's this idea of presumptive discoverability that was built into
Right.
it. Now, I understand later on that there was a kind of a carve back to allowing funders to reduce actual amounts, but that doesn't really necessarily solve the problem for the funders or frankly for the claimants.
Sure.
There's there's you can learn a lot from a party's analysis of a case by looking at how they've structured the funding, not just.
100%.
And so, at some point in time, if there's different amounts that go in on certain trigger events, for example, while the amounts may be clear, those trigger events may be visible,
Right.
right? And then, and of course, then also, are there, different levels of return metrics for time? And even though you may not know what the exact number is that's becoming the multiple, when
Yeah.
it suddenly becomes more valuable, right? So what advantage does that give the defendants potentially? And I think
Sure.
that's been probably one of the biggest concerns in our industry, is the extent to which any of this legislation would sort of not take into account that nuance and what kind of chilling effect that might have on funders, being able to actually be able to do these deals, and also, of course, for the the funded parties to actually receive such capital. A third aspect, which of course you and I see every day, which I think is very, is very much expected, and that is, the legislation prohibits funders from controlling litigation.
Sure.
every transaction document that we do provides for that.
Sure.
And, there's express statements about that. And we work really hard to make sure that there
Mhm.
is no sort of behind the doors control either over the case or the claim or the strategy. There really should be the independent relationship between the attorneys and their client on all those type of issues,
Sure.
not the funder. Um, Interesting enough that the Florida law also provided for indemnification for adverse costs, which is getting us closer to some of our European counterparts here.
Exactly. Yeah.
And certainly might be, welcome news to the AT insurance industry, right? If that became
Yeah.
a feature here. So that's an unusual component. And I think then kind of one of the biggest ones that I saw was, the sort of prohibition on assignments and securitizations that was sort
Yeah.
of built into the legislation. And the relevance of that is, particularly given some of these fundings, there has to be participation. There has to be multiple investors that come in oftentimes to help fund these very, very large amounts and diversify the risk across a pool of investors. The idea that you couldn't assign or securitize these, number one, would sort of prevent the mitigation of risk and
Right.
allocation. But I think it also effectively prevents these important financing sources from getting an exit, right? So they
Right.
can't exit from these investments. And as we all know, duration risk is a real feature of this industry. Cases can always take much longer. So,
Hmm.
will money be deterred from coming in because of the prohibition on assignments and securitization? I certainly think that it would be, which of course is in the end of the day not in the best interest of you know of
Right.
of the public and claimants and plaintiffs who rely on the financing to have their claims, their meritorious claims, see the light of day.
Yeah, for sure. I mean, look, on both the federal and the state side, look, you see all types of wrinkles touching kind of outlier situations, this and that, indemnity for adverse costs, foreign corrupt money. But one common thread that we always see is disclosure. As the litigator here, it's a fascinating thing to think about. If you are the defendant and you had, let's keep it real simple here, information as to the time adjustments for, uh, you know, a, um, a single case financing, or you had information as to the cost of capital and the rate adjusted cost, the time adjusted cost of capital for a law firm. And you are a law firm who is handling, as class counsel, a class action or mass tort. The amount of gamesmanship that could go on from the defendant's perspective and how that enters into the
Right.
litigator's toolbox it's fascinating. I mean, it truly, as if it's not already that, it could truly transfer litigation into a Moneyball situation with all types of, as if defendants don't already have the incentive to drag cases out. Imagine what they would do if they knew what the time adjusted returns to a litigation funder
Yeah,
would be.
absolutely. Um,
Yeah.
Yeah, so I think that the disclosure issue is sort of front and center here, right?
Yeah.
Of so many efforts, both on the legislative side, but also the court-based side. So, yeah, and I think there are some judges and others in the industry who are really trying to strike the right balance
Yeah.
on this. I mean, I know, Judge Conley in federal court in Delaware.
Oh,
He's seriously thinking about these issues and
yeah.
trying to get this right and trying to make sure that it's not an overreach, but not an undershot either. And I think for a lot of the courts, of course, they're concerned about, well, conflicts of interest. Is there some type of implied conflict of interest? And I know, I have colleagues who may argue, well, are there really conflicts of interest here? What could those really be here in the end of the day? But I think from a transparency perspective and confidence in our court system and confidence in this industry, I think a certain level of disclosure is going to be needed, and I think it's a useful aspect for this. I think the reasons for disclosure are and the purpose of disclosure need work yet. And potentially for conflict of interest, is there some type of controlling hand behind the litigation? I'm much more
Hmm.
sympathetic to that. I think the idea that funding agreements can be broadly disclosed is highly risky.
Yeah.
And maybe we have to rely more on sort of certifications by the
Hmm.
attorneys as to what these finance agreements do and don't do in terms of control,
Yeah.
oversight and case strategy, those kind of things. Um, but I do think we are going to see more and more pressure for disclosure here. But again, I do think it's maybe best driven by the court system, not necessarily a federal or even sort of state-based approach to this,
Yeah.
because it's one size doesn't fit all. I think there needs to be a lot of discretion given to the courts on this particular area. I will say that I think in our industry, there are a lot of voices now speaking up kind of against the industry, and they use a variety of approaches. A lot of the legislation you referenced earlier, are being heavily supported by those who oppose the industry. I've always found it kind of interesting, though, that when we start to get into a discussion with some of them about the details, for example, I've been in conversations with opponents to the industry, and they'll say, "Well, we believe this is kind of happening. We sort of understand this is happening," and I'll say, "But where are you seeing this in the agreements?" He said, "Well, we can't because we don't get access to the agreements, but yet I'll offer to share my template documents
Yeah,
and talk
exactly.
about them." But they never take us up on that. So, are we potentially, where is the real driver for this coming from? Are we
Yeah.
really trying to get this right? That we protect, the consumers and the claimants in these matters, versus sort of, the real conflicts of interest and things that
Yeah.
that can happen in any type of industry, that if not, careful eyes not kept on it.
Well, look, I don't know if there's anybody in the nation who, from the outside counsel transactional perspective sees more of these agreements than you. Let's wrap this up. What are your predictions, Mike Kelley, for how structures in litigation finance will evolve, if at all, over the next 5 to 10 years?
Yeah, I do think. I mean, it's something we think about a lot, because we try to look at what we're doing and where we're going to be, on this. And
Mm-hmm.
I do think, there is still this under kind of current of standardization of
Mm-hmm.
documentation, which kind of
Yeah.
comes and goes, right? I'm a proponent of standardization, sort of
Yeah.
in the consumer financing market side, because I think having sort of a standard set of terms and documents that are readable, understandable by an individual,
Mm-hmm.
and the view is they're consistently adhered to, I think is really important in the context where individuals are receiving funding.
Yeah.
I'm less concerned about it in the context of sort of more what are traditionally more sophisticated parties in a
Right.
commercial action, right? And I'm not sure we're going to, necessarily get to standardization of documents in the commercial context anytime soon. So I think we're still going to see kind of a mix of types of styles of documents. So there
Yeah.
still will be a lot of loan documents and loan transactions to law firms. I am seeing a lot more use of the variable prepaid forward purchase, and I think
Mm-hmm.
that will likely continue to be a very prominent way of structuring transactions,
Right.
unless there's a change in the tax law, for example, or maybe change in the bankruptcy laws, and that underpin some of the reasons why those type of agreements are attractive to
Right.
funders and to the funded party. So, of course, we never know what's going to come from the outside, but I would expect we'd continue to see sort of the similar forms of documents that we're using today. I mean, I do think in our mass tort space, there's going to be a bit of a sorting out, I think, that has to happen there. I think we're seeing so much money that's come into the space.
Yeah.
So many cases have taken so long, to get to final resolution. The investors are impatient. The law firms are stressed. And so there's a lot of systemic potential risk in all of that. And
Yeah.
and you want to make sure that people are thinking ahead about how do we bring some of these very large financings to fruition? How do we bring
Right.
them to a soft landing? Are there systemic risks in those relationships between funders and some of the very, very large mass tort law firms? I think some of those are done extremely well. There's other ones where I think, the funders have gotten
Yeah.
kind of over their skis, and the law firms too. So is there a risk to our industry, a risk to individual claimants because of that? So I think that's I think that's just an industry-wide perspective. That's something that I think about a lot more these days, because of kind of what I see going on around me and the transactions that we're sort of involved in here. So from a structuring perspective, those are some of my bigger concerns.
And how about legislation? If you had to read the tea leaves there, is there anything in particular that you think is going to stick or not stick?
It's interesting for me that a lot of these initiatives really they come forward with a broad brush, right? And then they don't actually get accomplished
Right.
in the end. And I think part of this is maybe because while on the surface they may be appealing or necessary at a certain level, I'm not sure they're well thought through. And because again, as I think talked about a couple of times here, we can't lose sight of the importance of the funded party here, and persons being able to have their claims be advanced by through the use of funding. So I think that we're going to continue to see sort of some broad brush approaches here coming out. I do think the courts are becoming much more educated. We see a lot of panels now with the judges at conferences who are coming into these discussions, and I really applaud that. I think they're attending
Yeah.
conferences and seminars. They're learning a lot, about all the different, so the law and the economics issues behind a lot of these
Mhm.
transactions, why the funding industry really provides a benefit to the judicial system. And I'm optimistic that it will cause the judges in our court system to actually develop a kind of a nuanced, kind of appropriate approach to making sure that risks are mitigated, but yet, the claimants still can have their day in court,
Great.
as well.
Awesome. Well, I think we're out of time, Mike. Thank you. Thank you so much for doing this. This was really great. I mean, look, you're part of a small club here who truly has a greater insight into these transactions than just about anybody out there. So your insight today was invaluable. Thanks, viewers, for joining us for episode 3, and hope to see you on the next one as well. Thanks. Bye bye.
Thanks very much for the kind invitation, Evan. Appreciate it.